And so our chapter is laid out by discussing the interference with employees' rights to organize by the employer, any employer discrimination against union members, what are protected concerted activities. We talked about or alluded to this duty to bargain in good faith in prior chapters, so we'll talk a little bit about that. We'll talk about the rights and prohibited conduct during the term of a contract, and we'll talk about the authority of the National Labor Relations Board. And then finally, we'll talk about the public sector and what unfair labor practices and contract enforcement means in that sector. As we've talked so far in the course, the public sector versus private sector generally have some very contrasted differences. And then we'll talk about individual rights within unions. That is, what are union member rights? And so the primary objective of the National Labor Relations Act, or NLRA, is to encourage collective bargaining in order to minimize industrial strife that adversely affects the free flow of commerce. And so, as we see, the overriding interest of the government is that we don't allow these labor management relations and the strife that sometimes exists between those two to impact the economy. And that's why the National Labor Relations Act was passed. And so the Act in Section 8A lists activities that are considered unfair labor practices in violation of those rights by employers. And one is to interfere or restrain or coerce employees in rights guaranteed under Section 7. Another is the domination or interference with the formation or administration of a labor union. So employers are prohibited from interfering with the formation or administration of a labor union. Employers are employers are prohibited from discriminating against union members regarding union membership. They are prohibited from discriminating against an employee for pursuing the rights under the Act, and they're also prohibited from refusing to bargain collectively with representatives of its employees. And so these are some of the activities that are prohibited in Section 8A of the National Labor Relations Act. Here we see some of the activities that are protected under the NLRA on behalf of employees, and that is the solicitation and distribution of information regarding union benefits, the right to unionize, being able to wear union buttons or insignias, having made available bulletin boards and meeting halls for union activities, the ability to engage in email solicitation, and then some control over employer rules regarding these particular activities. So employers are prohibited from keeping employees from engaging in or otherwise associating themselves with labor unions through these manners. Now, the NLRB has determined that certain activities during an election would constitute violations of the Act. And so in the event that a labor union is forming and there is an election in progress in order to determine that a union can be created, there are certain activities that cannot happen. And those are listed here. So the campaign, propaganda, and misrepresentation, right? Those who are organizing the union have to be fair and honest in what they're presenting to employees. They cannot make threats about losses of benefits. They cannot make promises or grant benefits. They cannot interrogate or poll employees. They cannot engage in surveillance of employees. And we have this 24-hour rule, which really came about in 1953 as a result of Peerless Plywood Company case, wherein the board detailed this 24-hour rule. And this has been in place for more than 50 years. This 24-hour rule prohibits employers and unions from making organizational campaign speeches on company time to large assemblies of employees within 24 hours of a scheduled election. And so that's what this 24-hour rule is referring to. And so when we talk about this idea of good faith, reasonable doubt, we're really kind of merging that with this idea of the duty to bargain in good faith. And when we talk about the duty to bargain in good faith, we're really talking about reasonable efforts that are demonstrated by both management and labor during contract negotiations. Now, where there is a reasonable doubt on behalf of the employer that bargaining in good faith would be exhibited, then the employer has the ability to request an election, to withdraw recognition and refuse to bargain with the union, and to conduct an informal poll of employees. And so essentially what this says is that an employer who thinks that a union who either proposes to represent the employees or who may have actually represented the employees in the past no longer has the employee support, then they're able to engage in these activities in order to satisfy any reasonable doubt or good faith reasonable doubt that they have that they will be bargaining in good faith. And so there are a couple of examples here of the typical unfair labor practices in an organizing campaign, or that is when no union previously existed and employees are trying to create a union. So one of these unfair labor practices, or ULPs, we said, was employer domination and interference. So under the NLRA, in addition to the campaign-related violations, employers' domination of and assistance to labor organizations are also employer unfair labor practices, and these unfair domination and assistance activities pertains only to labor organizations. And so other ULPs that could be engaged in by employers involve the idea of employee teams in the National Labor Relations Act. And the first item we talk about here is electromation. And so in the electromation case, the board found that the company or management illegally created and dominated a labor organization. The case involved the electromation company in Indiana, which was a non-union electrical parts manufacturer. The employer crafted 6 action committees to deal with employees on various issues. These committees contained members of both management and hourly workers, and they were charged with developing proposals for management consideration. The issues that were considered by these action committees included pay and absenteeism and the attendance bonus programs. The Teamsters Union had begun an organizing drive at the company about the time the committees were formed, and the NLRB ruled that the company had violated Section 8A of the National Labor Relations Act by creating the Action Committee, and the board decided that the committees had been formed for the purpose, at least in part, of dealing with the employer over conditions of employment. And so while this idea of domination and control of the labor organizations violate the Act, there's also some suspect given to the activities which may be a manifestation of the employer's legal cooperation with the union. If this support does not have any effect on the employee's exercise of their rights guaranteed by the Act and is trivial, then no violation will be found. Assistance or support that does violate the NLRA is employer aid to one or two competing unions. The employer can unlawfully favor one union by giving direct assistance to its campaign drive while allowing it exclusive use of company facilities by supplying the union with employee names to aid in the raid of another union's membership, and by assessing and collecting union dues without signed authorization cards. Discrimination against employees based on their union activities is an unfair labor practice and an obvious deterrent to successful collective bargaining. A violation of the Act occurs when an employer encourages or discourages membership in any labor organization by hiring or tenure practices or by using membership as a term or condition of employment. Discrimination occurs when a union member is treated differently from a non-union worker because he or she is involved in the union activity. In general, the fact that a particular incident took place is not an issue. It's easy to ascertain that a refusal to hire, a discharge, or a change in an employment condition has occurred. But an employer has a right to select employees and take disciplinary action to maintain good business conditions. The NLRB must weigh claims of discrimination by the employee against claims by the employer that certain actions were taken for cause. And so when we talk about this idea of anti-union animus, this is found when the employer's conduct is not motivated, or at least is not entirely motivated, by legitimate and substantial business reasons, but by the desire to penalize or reward employees for union activity or the lack of it. When we talk in terms of discrimination cases, we generally talk that they fall in two categories. One is in a dual motive discrimination case where there are two explanations for the action complained of that can be offered by the employer. One constitutes a legitimate business reason, and the other is a reason prohibited under the Act. The second category is a pretext discrimination case, and this is where the employer puts forth only the legitimate business reason, but the complainant asserts that that the prohibited reason is the true cause for the action. So the employer says, I entered into or I engaged in this action, and here's the legitimate reason why I can, where the complainant asserts that that wasn't the real reason, there was a prohibited reason that was the true cause for the action. And so approximately 60% of the unfair labor practice cases presented to the board involve a charge of discrimination for union activity. Discriminatory acts by the employer in compliance with a union shop provision in a collective bargaining agreement do not violate the Act. The Act specifically allows a collective bargaining agreement to require that new employees join the union within 30 days of employment. Employers that discriminate against employees for engaging in concerted activities violate the interference, restraint, or coercion provision of the Unfair Labor Practices section of the Act, and also violate the discrimination for purposes of discouraging union membership provision. Concerted activity is any action by employees to further legitimately their common interests pursued on behalf of or with other employees, and not solely by and on behalf of the individual. So the most common form of concerted activity is the strike. Concerted activity does not need to involve union leadership or membership to be protected. Only to establish concerted activity, certain elements must exist, and those elements include the issue must be work-related. The goal should be to further a group interest. A specific remedy or result is sought, and the act itself must not be unlawful or improper. The NLRA established a national policy to encourage collective bargaining as a way to eliminate or to mitigate industrial strife obstructing commerce. The employees seek strength in numbers by joining employee organizations to ensure equal bargaining powers. Under the Act, union organization is a right. It is protected and preserved. However, once the right is exercised, a duty is placed on both the union and the employer to proceed to bargain in good faith. So the Wagner Act made it unfair labor practice for an employer to refuse to bargain with representatives of his employee. The NLRB, in enforcing that provision, that is the duty to bargain in good faith, imposed a good faith efforts test as a condition for compliance with this duty. And so to illustrate this good faith, we see here that the labor organization is obliged to bargain in good faith, and in so doing, there must be an open meeting and conferring with the employer, or employees and the union must have an open mind in meeting and conferring with the employer, and they must sign any agreement that both parties have agreed upon. If we don't see these activities illustrated, then we can say they're suspect as far as the meeting the obligation to bargain in good faith. And then this idea of demanding status of exclusive bargaining agent for an inappropriate union is an unfair labor practice. And so there again, that demand would violate the duty to bargain in good faith. And we talked earlier about this idea of a strike, which is a type of concerted activity, right, that's protected under the Act if it's called for economic reasons, such as an economic strike, or to protest unfair labor practices, such as an unfair labor practice strike. And any retaliation against employees participating in a primary strike is therefore an unfair labor practice. For example, if a union member was fired for union activities, worker could stage a strike until the discriminatory practice was remedied. And there are certain illegal types of strikes as well. We talked about these earlier. If you recall, a sit-down strike was the takeover of an employer's property. That's a violation of the owner's property rights. This idea of a wildcat strike is an economic strike conducted by a minority of the workers without the approval of the union and in violation of a no-strike clause in an existing contract. A partial strike refers to various types of job actions such as work slowdown or refusal to work overtime. Again, this action is seen as a violation of the owner's property right. And then we have this sick out activity, which is really an organized effort to have workers call in sick. And in fact, in the 1990s, the fastest growing type of job actions was the sick out action. The NLRA also outlaws some consequences for which workers might strike. For instance, the jurisdictional strike could be called because two unions are in dispute as to whose workers deserve to work. A feather-bedding strike is a strike when a union tries to pressure the employer to make work for union members through the limitation of production, increasing the amount of work to be performed, or make work arrangements. And then there's the recognitional strike. That's when a strike is called to gain recognition for another union if a certified union already represents employees. So these are unlawful ends that might make a strike illegal. So we talked earlier about the different types of strikes that were illegal. These are just simply saying that if the purpose of a strike were to be one of these three reasons, even though the strike might not be recognized as one of the previously discussed illegal strikes, it would still be deemed to be an illegal strike. The U.S. Supreme Court, in the case of the National Labor Relations Board versus Weingarten, Inc., adopted what is today one of the most important concerted activity rights provided employees by the NLRA. The court held here that employees under Section 7 of the NLRA are entitled to have a union representative present during an investigatory review where the employee feels the interview may result in their receiving discipline. However, under this Weingarten rule, while an employee has the right to union representation during an investigatory interview, such representation is limited by the employer's right to conduct the interview. The role of the union representative is to protect the employees without interfering with the legitimate rights of the employer without turning the interview into an adversarial contest. The role of the union representative, therefore, is seen to lie somewhere between mandatory silence and adversarial confrontation. The employer cannot request that the union representative remain silent during the interview. The union representative may advise the employee against answering questions that are perceived to be abusive, misleading, badgering, confusing, or harassing. So as you may recall, back in Chapter 2, we talk about the Taft-Hartley Amendments. And these Taft-Hartley Amendments were really seen as a shift to a more balanced approach to labor relations. While labor unions were subjected to many of the same duties as employers. So the Wagner Act gave employees the right to organize. The Taft-Hartley Amendments recognized their right not to organize. Under the Wagner Act, employers were required to bargain in good faith. Under Taft-Hartley, that duty was extended to unions. So you can see that you may recall that the Taft-Hartley Amendments gave a more balanced playing field. So there are certain activities or actions that violate the Taft-Hartley Amendments, and you can see here that these are items like physical assaults or threats of violence directed at employees or their relatives by the union, threats of economic reprisal, mass picketing that restrains lawful passage to the workplace. So not all employees who are necessarily, unless they're in a closed shop, must be union members. And so if a strike is called, some employees may decide that for economic reasons or other reasons, they're going to go to work. And so, if the union members are picketing, they are not able to restrain lawful passage to the workplace. This idea of causing or attempting to cause an employer to discriminate against employees is also illegal. And then the idea that there could be discriminating provisions in the collective bargaining agreement that discriminate against employees who are not members of the union would also violate the Taft-Hartley Amendments and be illegal. So an unfair labor practice charge comes to the NLRB through procedures similar to the election petitions. The party claiming injury files an appropriate form with the regional office. An initial investigation is held, and if merit is found to the charge and the regional director cannot convince the party to settle, a hearing is held before an administrative law judge. The decision of the administrative law judge may be appealed to the National Labor Relations Board, which decides the case through a subpanel of 3 members randomly selected by its executive secretary. Any party who disagrees with an NLRB decision can appeal to a federal court. Recent statistics, however, do show that less than 3% of the unfair labor practice case brought to the NLRB actually ended up in a litigation process either in the NLRB or in the federal court. It demonstrated how cases are resolved through the NLB. And this just simply reiterates what we talked about earlier, that a claim is filed, the hearings are held. We try to fashion informal settlements so that parties feel like some equitable conclusion is reached. But the administrative law judge's decisions can be appealed to the NLRB. The NLRB decision can also be appealed to the federal court. And so this figure really just gives us an idea of the dispositions of the NLRB cases in 2009 and then the NLRB process. When a complaint is filed, it's assigned to an agent of the regional director in the NLRB region with jurisdiction over the parties. The agent is under tight restraints to investigate the charges and make a recommendation to the regional director. Our statistics here show that the decision of a regional director to issue a complaint or not almost always determine the outcome of the charges. With that in mind, the practice of the NLRB regional directors is to let the parties know which way the decision is going to go and give the losing party a choice of withdrawing or offering a settlement. And we can see here in figure 10.4, which is on page 394 of the text, that shows the disposition of the NLRB cases in a typical year in which some withdrawals and dismissals were resolved before the complaints were issued. You can see, on the left-hand side of the circle, we had withdrawals of a complaint or withdrawals of an allegation of 32% before the complaint was actually made, dismissals before the complaint was actually made, and then settlements and adjustments of 36%. For nearly 1.1 million federal government employees represented by unions worldwide, the Federal Labor Relations Authority, FLRA, is the independent government agency charged with administering federal labor management relations. Included in that role is adjudicating unfair labor practice claims involving federal government agencies. The FLRA is modeled after the NLRA, and it creates rights and obligations on the part of management and unions in the federal government workplace represented by a labor union. And it also enumerates various unfair labor practices for an agency. And so here we see where does the FLRA, or the Federal Labor Relations Authority, intervene, right? And what techniques do they intervene with in order to assist resolving disputes? And these disputes come up when there are numerous charges filed by the same parties, where both parties agree to the intervention process, both parties are committed to resolving their disputes, the charges concern institutional and relationship issues, the experience of both parties suggests that intervention may be useful, and there's a central office of the authority that provides support. Section 10J of the National Labor Relations Act permits the National Labor Relations Board to seek a federal court injunction in situations in which the action of the union or employer might cause substantial harm to the other party. The court, in response, can then order either party to resume or desist from a certain action. In general, the National Labor Relations Board must demonstrate that the unfair labor practice, if left alone, will irreparably harm the other side before a final NLRB decision can be administered, or justice delayed is justice denied. And a good example of this was in 2009, where a federal district court issued a Section 10J injunction against an employer, Vincent Metro Trucking, and ordered it to resume collective bargaining with the union food and commercial unions local. The court stated that the injunction was essential, just, proper, and appropriate because the NLRB was investigating unfair labor practices, and unless the injunction was issued, the employer's potentially illegal actions were likely to continue. And they really fall into the 13 categories that include union organizing, campaign interference, subcontracting work to outside employees, withdrawing recognition of the union, and it goes down and on, and you can read those at your leisure. This continues the list of the 13 categories for which most Section 10J cases have pertain to. The number of Section 10J injunctions issued by the NLRB, however, has declined sharply since 2000. Section 10J gives the NLRB at its discretion one of the most powerful tools to obtain quick injunctive release against a wide variety of unfair labor practices, which are detailed above and in the previous slide, committed by either an employer or a labor organization. However, in practice, most injunctions are applied against employers in cases involving the employer's refusal to bargain with a newly certified union, or employee termination or discipline cases. And so this concludes the important points in Chapter 10. I do encourage you to go back and make sure you've read Chapter 10 and are comfortable and familiar with the information in it. And then please move on to, after you've gotten Chapter 9 and 10 both under your belt, please move on to the discussion forums and the assignments. And thanks for your attention.